Hi, thank you for joining in LawKNIT sessions. Amol, are you there?
Yes, sir.
Yeah. Is my slide visible properly?
It is.
Okay. Hi. So this is the second session for our LawKNIT learnings. Those who have joined first time, I'll just give you a brief background of LawKNIT. So LawKNIT Partner is a law firm based out of Bangalore, Mumbai, and Indore. We conduct a quarterly session for our clients as well as for our internal team on various issues which are more relevant from a day-to-day legal perspective. Uh, Majorly, it's a once a quarter, two session or a three session series, and very time bound half an hour session where we pick up something which is very a day-to-day something which is easy to understand for everyone, even for non-lawyers. Like for example, this session, the topic is in relation to legal notices. What we have been seeing with our clients and uh, with with other connects, what we understand that whenever a legal notice is served in an organization, there always a kind of a uncertainty with regard to that legal notice, whether we should accept that legal notice or we should avoid that legal notice. If that legal notice has been served through a non-registered post, someone coming and doing a hand delivery, do we have a right to say that we are not authorized to take this notice, or is this notice a genuine notice to be even considered? Okay. So what we have seen that there are a lot of confusion, especially with regard to legal notices when it is served on you, and at times when you are going to serve it to someone. Okay. So we have divided our session into two parts. Uh, Today's part is with regard to when we are, as a client, served by a legal notice. Someone comes and gives us a legal notice. Then what should be our course of action? Second session, which is on 22nd, is on when we are supposed to send a legal notice. Now, the question remains is that when to decide that it's enough is enough, now we should send a legal notice. And if we have to send a legal notice, then we have to appoint a lawyer. Does it required? And so many other issues around that. So that is the second session, which is going to be held on 22nd. So today's session is focused on when a notice is served on us. Okay. Just some housekeeping rules. You can put your queries on chat. Okay. We will try to take those queries while we are discussing this issue. And at the end of the session, we have kept 5 minutes to discuss the queries and even have some interactive sessions on this. Or the third thing can be done is that on 22nd, when we are coming for our second session, we can club all the queries with regard to the first session and second session and discuss it on our second session. Okay. So now take you through the roadmap what we are going to discuss today. Okay. Now, the first and foremost question is that what is the purpose of legal notice? Okay, if if does it serve any purpose? Most of the time, if you would have sent legal notice and you would have realized that there is no result which comes out of legal notice, or at times the legal notice has sent and ultimately you end up fighting it out in an arbitration tribunal or in a court. So the question always remains that what is the purpose of having or even sending or having a discussion over the legal notice? Then the distinction which we need to understand a difference between a legal notice and a statutory notice. What does a statutory notice mean and how does it look like? Okay. Now the third is, which we will be discussing a little bit more in detail, is regarding the actions. Once you have been served the legal notice, what exactly should be your action? What are the common mistakes which one should avoid when a legal notice is served? And the other issues with regard to refusing to take legal notice, or most of the legal notice, if you see, they have a timeline that please reply to this within 15 days or 30 days, and also along with a cost of 50,000 rupees, which has been incurred by my client. That's what the other side lawyers and the notice says. then what does that mean? If I don't reply in 15 days or 30 days, as mentioned in this particular notice, then what's going to happen? Means, will it be taken negatively against me? And the last portion which we'll discuss, preparing reply to legal notice. Once we have to prepare, then what we exactly need to do. Now, coming to the first topic, what is the purpose of legal notice? Does it at all serve any purpose when it comes to legal notice? At this stage, I would like to bring Amol. Amol, what exactly, and just to give you a brief background, Amol has been doing dispute resolution for last 20 years, and he is partner based out of Bombay. My introduction, I'm Arnav Chaudhary. I'm more of a general corporate tech lawyer and M&A practitioner, and I'm based out of Bangalore. So it will be more of a taking interactive sessions with Amol and also doing our own experience which we have seen around it. So yeah, Amol, back to you. What do you see as a purpose of a legal notice? Does it serve any purpose by sending or receiving a legal notice?
Yeah. Thanks, Aruna, for that. Uh, so, first and foremost, a legal notice, when we say legal notice, it's a notice sent to us by a law firm or a lawyer, either to do certain things within a stipulated time frame or to refrain from doing certain things within a stipulated time frame. Now, this legal notice, while there is no specific provision in law other than certain specific acts like Negotiable Instrument Act, etc., where a demand notice or a notice is mandatorily to be sent, or IBC proceedings where notices are mandatorily to be sent. Not for all purposes you end up sending legal notices, or it is not mandated by law everywhere. Then why do you send a legal notice or why do you receive a legal notice? It's kind of a last warning to your counterparty that do XYZ things within a stipulated time frame. Otherwise, we will be forced to take the legal recourse to redress our grievance. A legal notice is a communication about a grievance where you raise the grievances and then demands associated with that grievance. It may be demand for money. It may be a demand for completion of a particular contract within the stipulated time frame. It may be ask regarding a breach of a commercial contract, or it may be simple ask for refraining somebody or asking somebody to refrain from using, say, your IP marks or whatever. So it's a formal written communication sent with an intent to call upon the other party to either do certain things or not do certain things within a stipulated time frame so that dispute gets resolved before it reaches a judicial or a quasi-judicial forum.
Got it. So one important thing which you raised here, that it is sent by a lawyer to you. So at times what we have seen that if two parties enter into a contract, okay, now that contract dispute resolution clause also has a stipulation of sending a legal notice. Okay, so you cannot go to court, you cannot start a proceeding until unless you have sent a legal notice of 30 days or something, which is mentioned in the contract. So at times, parties also send this notice just to meet that requirement which is under that contract. Okay,
Yeah.
so yeah,
Sorry. So as I said, I mean, either it's a statutory requirement or it is a mutual understanding or a contractual requirement that the parties have kind of imposed on themselves when they entered into a contract, or or it may be also a, even if it is not a statutory requirement or a contractual requirement, but it may serve as a reasonable opportunity of being heard. A principle legally, in legal terms, you follow a principle of opportunity of being heard, which means that you give a reasonable opportunity to the other party to resolve or at least come forward with their stance. So these are the three reasons why a legal notice is essentially sent.
so we'd like to show a kind of a format for legal notice. Yeah. Okay. Coming before to that. So now once we understand that what is the requirement, sometimes the requirement is your own contract, and at times it's a final warning with all set of facts and everything, and as well as the demand which is there comes out of a legal notice. So one can see that as a final requirement from the other side, what they are wanting us to do. Now, the question comes here is that is all legal notice which is being served on us, is there a way to understand which is actually a legal notice which is going to get into the court, or which one we should wait a little more to see that, because we see that one notice has come and then the second notice comes. People may not end up directly going into the court. There are multiple notices which keeps on coming. So is there a parameter to understand what is the legal notice? This is the finality and we should start acting on it.
Uh, so yeah, I mean, there's no written law. Again, as I said, there are certain statutes which actually provide the mechanism as well as the processes to be followed for raising the demand or sending the demand notices. Like I said, in cases of check bounce, there are limitations prescribed. You have to send a notice
Yeah.
within a stipulated time frame. That notice has to be responded within a stipulated time frame, etc. We will not discuss the limitation, etc. there, but there are certain statutes which prescribe the procedure. Then there are certain contractual agreements which the parties have made among themselves that will say quite a lot of contracts these days, commercial contracts specifically, have clauses where the parties actually agree on sitting across the table and resolving a dispute. If that doesn't work, then serving a legal notice. If that doesn't work, then taking it to mediation. And if that doesn't work, then finally taking it to the dispute, so that you give an adequate opportunity to each other to resolve a dispute. Now, when to respond, when not to respond will obviously depend on a case to case basis. But uh, re- keep in mind that things which are statutory in nature, or the notices which are statutory in nature, like check bounce related cases, etc., need to be responded within a stipulated time frame, and therefore it may be advisable to actually consult your legal advisors or in-house legal teams to have a look at the notice that you have received to figure out whether this needs urgent response or no. Sometimes notices are vague in nature. Sometimes notices are sent just with an intent to extract more information from your side. In those cases, probably you may avoid responding to it, or you may choose to respond it slightly vaguely, but that's a call that your legal experts will take. Uh, Otherwise, if it is in the nature of IBC, Section 138, check bounce cases, etc., there is a timeline that you need to adhere to. And therefore, the sensitivity in those cases increases manifold. Uh, the other thing, and which is visible on this slide, Arnav, is that internally, sometimes because these terms are not defined, we may confuse certain things with each other. So there's a notice which we call as legal notice. Typically, those notices are sent by advocates on their letterheads, and those are like pre-adjudication kind of notices where uh, it's kind of a last warning that if you don't do certain things which have been stipulated in this notice, then we'll be forced to approach the court. So it has not reached the court as yet. That's where that's a legal notice typically. It may also be about a notice may also be about certain filings that the lawyer has already done and they want to intimate you in advance. That's a different scenario. But typically, a legal notice is a pre-litigation kind of a stage. Whereas there are certain other notices which, in general parlance, in layman's language, are called as legal notices, but they are either from a statutory body, say, for example, income tax department, GST, sales tax, stamp authorities, or revenue authorities in any other form and shape. Those notices are sent by a statutory authority either because there's some non-compliance or because they are seeking some information under a specific statute, or I don't know why these balloons are flying on my, but anyways, so
Yes, sir.
uh, uh, or it may be calling for an inquiry, or it may be also a show cause notice issued by a statutory. So one needs to be very careful in terms of which section these notices are issued under, which statutes these notices are issued under, what is the sort of uh, uh, the information that is sought or the direction that is given in those notices. So if they call upon certain documents and information, then there will be a stipulated time frame within which you have to supply those documents to the authority. Uh, Again, in these kind of cases also, it's best to consult the legal advisors because they know best as to how to respond to these kind of notices and what circumstances do you need to respond immediately, in what circumstances you can't respond. Sometimes you can't actually practically not respond to them within the stipulated time frame. A lot of times it so happens that you receive the notice today and the
Yeah.
timeline is say tomorrow or day after, and the
True.
notice actually asks you to submit plethora of documents and information which is just practically impossible to collate and collect. In that case, your advisor will advise you to, uh, or rather, draft a reply on your behalf seeking some more time from the authority. So, all that nitty gritties is something that your legal advisor will better understand. But any statutory body or a government body, be it a state government body or a central government body, sending notices typically fall under statutory notice categories. And then there is obviously a third category, which are court issued notices. So the dispute has already reached a court and the court is giving you an opportunity to present your case or to represent your case through a legal practitioner or an advocate, which is typically called as wakalatnama or a letter of authority, or in some courts, it's called power, which you file and then represent your case through a advocate in the court. So then there will be third category, which is court notices. Now, this court notices also uh, is a very critical document because it may not always be a notice. It may sometimes be a summon. It may also be sometimes be a warrant. It may sometimes be a warrant, but a bailable warrant. Sometimes it may be a warrant which is non-bailable warrant. And the actions in all these kind of cases are different. And the criticality also in all these cases is different. And therefore, the best thing to do is the moment you have it in your hand, take it to your legal consultant or your in-house legal teams and uh, hand it over to them for further action. Don't sit over it because, as I said, if it is a non-bailable warrant, uh, I'll just give you a random example. Even
Yeah.
a consumer forum matter. Say, for example, you've lost some consumer forum matter. You're an organization and have lost a consumer forum matter before a district forum. You're not aware that the order has been passed and there were timelines prescribed to comply with that order, and you did not come across the order, or you, for some reason, you missed out on compliance. There are execution proceedings before consumer forums. If those execution proceedings are initiated, the forums issue warrants, and typically those are issued in the name of MDs and CEOs. And if those are first warrants, then they'll be bailable warrants, which means that the police authority who is serving those warrants to you can give you a timeline or give you a bail then and there, and then you can appear on a designated date before the court. You have to appear in person, and therefore it becomes very, very critical to handle. If it is a non-bailable warrant, then there's no way the police can give you a bail, and the only responsibility that police guy has is to visit your office, pick up the person whose name is mentioned on the warrant, and present him before the court. So then the criticality needs to be understood very carefully. And it's not possible for every layman to understand those criticalities, and that's why I'm again and again saying that whenever you receive something like this, take it immediately to either a legal consultant or your legal team so that initial actions which are required can be taken well within time.
Got it. So, and leaving any notice or not attending a notice will create more of a problem at times.
Yes, I mean,
Yes.
more often than not, it will create a problem because, as I said, I mean, even if it is just a simple lawyer's notice
Yeah.
and you don't attend to it, it's like a final warning, right? There may be a possibility for you to resolve it before it reaches the court. Once it reaches the court, irrespective of the gravity of the matter, it will end up consuming a lot of time, money, and effort. So even if
Yeah.
it is a small issue, it's always advisable to address the legal notice then and there, so that if there is a possibility of resolving it before reaching the judicial forum, you can do it. If there's a possibility of putting forth your stance on record, so that the other party also understands that you are not weak in the matter, you should take that opportunity. And in any case, as I said, the principle is reasonable opportunity of being heard. Courts typically will say, was there a legal notice served on you? Yes. Did you receive it? Yes. Was there enough time given to you to respond to it? Yes. Did you respond to it or chose not to respond to it? No. Uh, it may not have a fully negative bearing on you, but it will still play on the court's mind that you are not paying that
Importance to the matter.
importance to the matter.
Correct.
So that can be a problem.
Yeah. Now, once the notice is received by an organization, okay, one thing which I have seen and as a practice which is to be followed by the organization, that once you receive the notice, the important document is within the envelope, but envelope itself is very important because the date of receipt at times are mentioned on the envelope itself with a stamp. Okay,
Yeah.
so as a practice, we never throw away the envelope. We keep the envelope and the document together so that it is whenever we are going to the court and filing in the court, that envelope becomes an evidence of the date on which you have received the notice. Okay,
Yeah.
so as a practice, that's any document attached along with the notice, any acknowledgement, anything, whatever has come has to be preserved and kept it together. Now, Amol, one thing which we have seen is that at times employees assigns receipt of a notice either through registered post or courier or anything. Is there any implication of employee signing on behalf of a company for receipt of a notice?
So again, it depends on case to case basis. Typically, in all civil matters, if there's an employee, typically notices are received by the front desk. You have your receptionist on the front desk who is a designated employee to receive uh, all the incoming posts and communications, etc. The responsibility of that person is to, whenever the postman, typically these notices are served by registered post AD. So the responsibility is to put up a stamp, company stamp, and sign and date, and that goes to the court. So there's no harm in accepting some if you don't have that mechanism available in your organization. Ideally, whenever you receive a notice, the first thing you should do is to obviously do all that formality that I spoke about to give stamp, seal, sign, date, mention the specific date when you received it in the AD that you are giving back to the postman. Also, it's a good practice to either keep a tracker or a inward register in your office where you actually enter the date of receipt, the description of what has actually come in on the envelope. You'll actually see where it has come in from, and then date and time of receipt. Also, it's a good because from there it will go to the legal team. Sometimes organizations are large. It's a good practice for a in-house legal team to mention the same things at the back of the notice so that there is a record. Obviously, nowadays teams follow or have their record management system, etc., online. But it's always a good practice to keep it uh, as a record at the back of the notice, handwritten and signed, so that you know exactly who has received it. Now, why I'm saying this is in a lot of civil matters, where the dispute is all about whether the notice has been received in time, not received in time, whether it is barred by limitation, etc. These things play as evidence. Also, the person receiving it may become a witness, and therefore it's critical for you to record it properly so that the evidence is clear.
Got it. Uh, so once we have received the notice, obviously, as you said, we'll in the organization should go to in-house lawyers or external someone to analyze it, whether it's a statutory notice, whether there's a timeline, what all we need to do about it. Now, technically, when we are making reply to notice, there are few things which we keep on mind. Okay, one is as you said that whether to reply or not to reply is if it is just a legal notice, not a statutory notice, it's not an offense. Okay, but it always plays in the mind of the court that if you have not responded to a notice, then are you taking this matter seriously? Okay, and if from all those perspectives, so it plays in the mind of the court with regard to your promptness with regard to that matter. Now, the other thing which I would like to highlight it here is Amol, with regard to the counterclaims. So when we are responding to a notice, what opportunity we have now? First we will deny whatever has been said to us. We have seen
Yeah.
people have denied to an extent of name also, that I don't know,
Yeah,
I don't admit that my name is this. You need to prove
yeah.
it. So how this denial and counterclaims works when we reply to a notice?
So this goes to the civil proceeding, and just like you narrated one small incident, I remember one small incident when it's actually not a response to a legal notice, but in a court, I've seen. So in civil proceedings, categoric denial of certain allegations is very important. So what you actually do in civil proceedings is A, you either admit or deny the allegations made against you. And if you're denying certain allegations, then you just don't stop at denying. What you do is to deny and then put forward the correct facts in your opinion. What is the correct fact? That's how you actually do it. One of the incidences that I remember, and typically in MP, the lower court proceedings are in Hindi. So there was one paragraph in a civil suit which stated that Mr. So and so का स्वर्गवास इस दिनांक को की मृत्यु इस दिनांक को होकर वे स्वर्गवासी हुए. Now it goes to a level of categoric denial which I was talking about, and I've seen that reply where the opposite party, when submitting its reply, stated that इनकी मृत्यु होना तो स्वीकार है पर स्वर्गवासी होना स्वीकार नहीं है. So
I don't know
sometimes
whether
lawyers go
yeah.
overboard, sometimes lawyers go overboard, but yeah, the important fact here is that uh, if there is a scope for you to deny allegations, yes, you should. If there's a scope for you to narrate the facts the way you think have actually occurred, you should. And if there are claims made by the other party and you have counterclaims, you should. And I'll tell you one benefit of it also. It also depends on which stage of dispute you are. Sometimes making counterclaims in response to a civil suit rather than just a legal notice can be of great help because one who files a civil suit has to actually pay the court fee, and that court fee calculation is basis the demand that you make in your suit, money suit, and it's certain percentage of the demand that you have made. But there's no court fee on the counterclaim. So when you file your response and make counterclaims there, you end up saving on the court fee. So it's a strategy that you need to figure out on a case to case basis as to how much of it you want to state in a legal notice. As I said before, also that sometimes lawyers send a legal notice just to seek further information, and it happens typically in corporates. I don't know. There were a couple of our friends who were from insurance industry, whether they've joined today or no. But I've seen this in insurance industry where the lawyers will send a vague notice to you because they don't know anything about the policy terms and conditions. They don't understand after looking at the policy document what it covers, what it does not. So they'll send a vague legal notice. And in-house teams in insurance companies have a standard practice of following a template of response to a legal notice. So they'll start with proposal was submitted on this and this date, policy was issued, risk commencement was this and this, that and that, and they'll narrate all the facts and then start denying. Now, what has happened is the lawyer who did not have any information at all has been served with that information on a platter. Now he'll use that in a consumer forum case. So you have to take calls on a case to case basis as to how much do you actually want to state when you respond to a legal notice.
That's pretty important. Yeah. Yeah. Now coming to the some of the common mistakes which one can avoid is, of course, we have discussed the ignoring legal notice. And the second aspect is that once you receive a legal notice, what we have seen, that a casual WhatsApp communication or a chat communication or a email communication at times go against it. Okay, so if someone has served you a legal notice, be ready that it has become a lot more formal. Stop any kind of and in fact, one should also inform other employees who are engaged with that other side not to go for any open talks or WhatsApp messages or emails, because those goes very much against the company. Okay, and once a legal notice has been received, as a good practice, it should be told to everyone in the organization who's working with that client, not the details of the legal notice, but at least that the communication should be channeled. Someone has to look those communication before releasing it. There's nothing. as a relationship left over to be continued, one need to have professional help there. Second is with regard to preserving evidence. Okay, now the flip side of telling to everyone in the organization that this notice has come, if someone has created any or done any mistakes in past as an employee, they tend to hide it. They tend to delete it, or they tend to remove those. So those also create a lot of problems. If certain email chains has been deleted and all those things. So there has to be a particular do's and don'ts when it is being communicated that don't touch anything with regard to this matter. If whatever has gone out and come in, there is a record. Just by you deleting it will not go out. We'll figure out a way. But preserving evidence and preserving communication also becomes one of the important aspect to this. Now, at times there are changes of address. Okay, so when you entered into an agreement, there was an address of the company, or you had given a different address in that agreement, and now your address has changed. Now, typically, when you receive a notice on a different address, it's little tricky. You can deny that notice that it's not on correct address, but it doesn't make any difference to the factual situation. So, but when you are sending a notice, that is a point which we will cover in next session. It's always important to send on all the addresses which is available with you, which was there in the agreement under the notice clause, and whatever you are aware of currently. And then to be, the details is anyway, Amol has discussed that what all details should go into the notice. But whenever you receive a notice, always check once your notice clause and the requirement mentioned in those agreements, because we have seen in one of the foreign matter, the notice clause was very typical. It's a UK based legal agreement, and it says that notice has to be served on the table. That's a very peculiar kind of a demand, and then we understand as a common law practice in UK, on the table means that you cannot hand it over in the hand. It has to kept on the reception table, and you have to leave it and come out. You cannot hand it over to someone. And those things goes into technicalities when someone goes into court, so that those becomes pretty important aspect. Now, coming to the last slide, key takeaways. Amol, how would you like to conclude our discussion for today?
So the key takeaways are, and starting from knowing and understanding basic difference between a legal notice, statutory notice, and a court notice, because that will give you a first hand understanding of the criticality of it. Also understanding that all these three types of notices that we spoke about, the time and the timeliness of action or appropriate action is very important. And therefore, if you're not a legal person and receiving a notice, then taking it to the legal team is the action on your part. Responding to a legal notice within the prescribed time frames may be an action item for the legal team or their lawyers to do. But understanding that critical action that you need to take within quick time is the second thing that you need to keep in mind. Uh, as we discussed, uh, there is way in which you have to receive, in which you have to take a legal notice or a statutory notice forward, and those things have to be followed in terms of recording when received, what time it is received, which date it is received, which date it is handed over to the legal team, etc. Can be of helpful. As Arnab said, the envelope also is an evidence, is a piece of evidence, and therefore, if you have a habit of taking the letters out and tearing off the envelope, at least in case of statutory notices, legal notices, you shouldn't do it. You should preserve it. So those small things which help you in better handling of the notices should be kept in mind. And last but not the least, is the smaller mistakes like ignoring it, or just throwing it in a dustbin, or just saying that these keep on coming. Sometimes in a organization which is litigation heavy, you will keep on receiving these legal notices on a very regular basis. I've worked in some of the largest financial service sector companies, and the frequency of receipt of legal notice used to be sometimes 300 odd notices in a month's time, which is like 10 per day, including the holidays also. So it can sometimes be very high, but then avoid a mistake of ignoring them, not taking appropriate action, or simply sitting over it. Those kind of actions should be avoided if you want to better handle the legal notices.
Great. I think here we would like to rest our slides. Anyone has any question? I think we still have 3-4 minutes left. Uh, Please feel free. In the meanwhile, just introduce LawKNIT offices to you. And we have 3 offices, and we also have a LawKNIT tech platform which help you in managing your in-house legal requirement, especially with regard to documentation, drafting, and other aspects. Yeah. So anyone has any question, please feel free to ask, or we can very much take up in our next session or our, next session will be on 22nd October, same time, 4 p.m. I think the reminder emails will go half an hour before the session. Yeah. We'll wait for a few minutes to